Well, good morning again. Thank you, everybody, for moving up front. This is a great day, and welcome to Sunshine in the City. We're very, very honored to have Miss Barbara Peterson here, who's president of the First Amendment Foundation. Barbara attended the University of Missouri in Columbia and Florida State University Law. So today's going to be an excellent day. I would like to welcome all our public officials. I do see some out there. We've got some friends that traveled, I believe, from Century and to the east. So if you're an elected official, will you please stand up? Councilman Bear, I do see you. Councilman Johnson, I think I saw you walk in. I want to thank all the elected officials for being here. Councilwoman Myers, there you are. And most importantly, I want to thank a lot of the volunteers that I see in the audience that serve on boards. The sunshine is incredibly important, and I believe we have great people that want to serve our great city, and sometimes it's challenging, it's difficult. We don't know the right questions to ask, or we don't know what we're asking. But the unique thing about Pensacola is we've got incredible employees, so I want to thank all our employees for being here today. Give yourself a hand. As a city of Pensacola, I felt like it was very important to take a leadership role in this, to talk about the sunshine and talk about public records. And we couldn't have a better individual doing that today. Without further ado, I'd like to welcome Ms. Barbara Peterson from the First Amendment Foundation of Florida. Barbara?
Thank you very much. I think you can give that back to Lenny.
You got it.
Good morning, everyone. Thank you, Mr. Mayor, for introducing me, and thank you all for coming this morning. For those of you who are not familiar with me or with the First Amendment Foundation, the foundation was created in 1984 for pretty much the sole purpose of protecting the public's right of oversight of its government, and the traditional purpose of open government laws. And we've had some notion of open government in this country since the founding fathers. James Madison is considered to be the father of open government in this country. And the traditional purpose was for government oversight and accountability. Without access to government information, the public cannot find out what its government is doing on its behalf. And that was the sole and traditional purpose. And it hasn't changed that much, although there are people involved in commercial activities who want public records for commercial purposes. Reminds me, turn your cell phones to vibrate. And I have mine just for the clock purpose. The foundation was started, as I said, in 1984, and for a long time, 10 years, it had no staff. It published the Government in the Sunshine Manual every year. We still publish this in cooperation with the Attorney General's office. This manual is extremely helpful for anybody who has anything to do with open government, whether you're a public officer, a volunteer, whether you're an employee, whether you're a citizen, whether you're a reporter. This manual explains everything you need to know about both the open meetings law, which we refer to as the Sunshine Law, and the public records law. It is now quoted in court cases. It's the legal authority. And you can either now get the hard copy. We sell it also on Amazon. It's a lot cheaper on Amazon. Or you can download a PDF version from the Attorney General's website. So you have lots of different options for getting a copy of it. In addition to publishing the manual, the foundation operates a toll-free hotline. It's a free call for anybody, anywhere, who has a question about the public records law or the open meetings law. When I started at the foundation in 1995, we had about 200 calls that year. We are now averaging about 150 calls a month on our hotline, and that does not include the emails we get on a regular basis. My general counsel and I answer all of the questions. There are questions I get. I've been doing nothing but open government law since 1991. And there's not a day that doesn't go by that I'm not asked a question I've never been asked before, and I honestly don't know the answer. Chances are somebody's going to ask a question sometime today. I'll say, I don't know. If I don't know the answer, I will talk to people who might be able to help me figure the answer out. My general counsel, Pat Gleason in the Attorney General's office, I've got her on speed dial. Everybody constantly is asking everybody else questions, because this, as you'll find out, is not always easy. And it's not always easy to tell when a meeting is a meeting. It's a lot easier to tell when a record is a record, but it's not always easy to tell when a meeting is a meeting. So we operate the hotline, we publish the manual. I monitor the legislature during its annual legislative session. You may know that only the legislature can create exceptions to either the right of access to meetings or the right to access public records. So the legislature is constantly monkeying around with the law, making changes. There are a couple of new changes that are going to affect you, in addition to some new exemptions that I'll cover this morning and this afternoon. And they file about 120 bills, 130 bills a year that create or would create new exceptions to the constitutional right of access. So it's my job to track those, to analyze them, to report on them. If they're just bad public policy, or if they could be tweaked just a little bit to conform to the constitutional standard, I will communicate that with the sponsors and work on the language so that we have an exemption that fits the constitutional standard. It's not too broad, it protects the information it's intended to protect. That's a big part of my job in the spring. And then I do sessions like this. Every fall, the First Amendment Foundation hosts a series of sunshine seminars where I literally rent a car in Tallahassee, spend 2 weeks driving around the state of Florida talking to hundreds of people about open government. And the last time I was here, I think was 2 years ago, a seminar sponsored by the Pensacola News Journal. We had a couple of hundred people in attendance. It was a really good event. So I do about 8 or 9 of those every year, and then I get requests like this from the city of Pensacola, where I come in and talk to city employees, public officials. A citizens organization will want me to come talk to their members, and I do about 30 or 40 of those a year. So I'm pretty well versed in open government. In fact, I refer to myself as a one-trick pony. It's all I do. So do not ask me a question about anything else, because I can't answer it. But I have done nothing but open government since 1991. When I graduated from law school, I was a late bloomer. I graduated from law school, I went to work for the legislature, analyzing the impact of advances in technology on the public records law. It's hard for some of you to believe, but in 1991, we did not have cell phones. I got my first cell phone in 1995. It was this big and weighed about as much as a brick. We're just starting to use email. The internet was not what the internet is today. We had something called dial-up billboards, and you had to have a telephone modem to dial into the computer system, and it was a black screen with white writing on it. That was the technology in 1991 that we were dealing with. And look at where we are today. I mean, who would have ever thought of tweets? Not back in 1991 or even in 1995, which was the last time the public records law was changed to deal with access to electronic communications. Think where we've been since 1995. The legislature, if you haven't figured it out, can work really fast when it needs to. But most of the time, it works very, very slowly. And it can take 3, 4, 5 years to get a bill passed. So I worked for the legislature as the staff attorney for the Joint Committee on Information Technology Resources for 4 years. And then in 1995, I moved over to the First Amendment Foundation, where I've been ever since. The foundation is very small. You're looking at about half of it right here. I have a staff of 1.5 in Tallahassee, but we do a tremendous amount of work. It's a job that I love and am very passionate, actually, about the work I do. I like talking to people. I like working through problems with people. So it's been a very good and very rewarding job. This morning, we're going to talk first. We're doing this a little differently. You're getting a more intense session, whether you like it or not. We're going to do Sunshine Law this morning, and then at 1 o'clock, we're going to come back and do the public records portion. This evening, I'm going to be talking to anybody who shows up about the importance of open government and answering questions. If you have a very specific question about a specific situation, I think you've all been given note cards. If you fill out that card with your question and sort of raise your hand, somebody will pick it up. We'll answer those questions as we have time. If you put your email address on it, and we don't have time to answer today, I will, when I get home, answer your question via email. If you have a question about something I'm talking about you don't quite understand, you want to know how it might apply in a given situation, there are microphones here on each end, and you're welcome to come up and ask your question. I do depend on people to ask me questions, and my presentation here this morning is going to be pretty basic because I'm not sure how much people know about open government. So I depend on you to take it down to a deeper level, and we will have plenty of time, I think, for questions, both written and any question you might have during the presentation. In Florida, when we talk about open government, our Sunshine Law, the Open Meetings Law, we always have to start with the Constitution. Article 1, Section 24B of the Florida Constitution, we have both a statutory right and a constitutional right of access to the meetings of our government. The statutory right, Section 286.011, was enacted in 1967. It was one of the first open meetings laws in the country. We recently at the foundation did some research and published a white paper on the history of open government in Florida, and I learned for the first time that our first open meetings law was actually enacted in 1905, but nobody paid any attention to it. So the legislature repealed it in 1950, and then in 1967, Senator Red Cross was finally able to get the modern Sunshine Law, Section 286.011, passed by the legislature. Then in the 1992 general election, we had a constitutional right of access to the records and meetings of our government on the ballot in the general election. At the time, it had the highest voter approval rating of any constitutional provision in the history of Florida. So Article 1, Section 24B says that all meetings of any collegial body, that's a committee, a commission, a board, a task force, all meetings of any collegial body of the executive branch of state government or of any county, municipality, school district, or special district at which official acts are to be taken or at which public business is to be transacted or discussed shall be opened and noticed to the public. A couple of things I want to point out here. At which official acts are to be taken or at which public business is to be transacted or discussed. The constitutional right of access applies to the entire deliberative process. A lot of people seem to think that it applies only when the commission is going to take action. But why a decision is made, how a decision is made, everything that leads up to that vote is critically important to the public's understanding of what happened. And the constitutional right of access applies to the entire deliberative process. So not just those meetings where you're going to take a vote, but meetings where you will be discussing public business. Second, you might notice, this does not apply to the legislature or the courts. It applies to state agencies and local governments only. That's because there are other provisions in in the Constitution that apply to the courts and the legislature. The legislature is bound by the requirements of Article 3, Section 4E of the Constitution, which says that prearranged gatherings of more than 2 members of the legislature must be reasonably open to the public. Anybody who deals with our Sunshine Law knows that the legislature is subject to a far lesser standard than is applied to city commissioners, public boards, school boards, county commissions. Prearranged gatherings. That means that the House Speaker, the Senate President, and their budget chiefs can accidentally bump into each other in the halls of the Capitol on a Saturday morning, sit down and have a meeting. What I particularly like about this provision is that it is subject to the sole interpretation, implementation, and enforcement by the legislature. So the legislature gets to decide what this means. They get to apply it to themselves, and then if they violate it, they get to punish themselves. Nobody else can punish them. And there's a huge frustration from citizens all over the state of Florida who come up to Tallahassee, take days off work to come talk to their legislators, and they're not allowed to get into a meeting. And some legislators have tried to change this to hold the legislature to the same standard as applies to city commissions and school boards across the state, but they haven't had much luck. The courts are not required, are not bound by the provision in Article 1, Section 24B, but the First and Sixth Amendments of the U.S. Constitution guarantee open judicial proceedings. So we do generally have a right of access to judicial proceedings. Courts, however, have the inherent authority to control their proceedings. So after a balancing of interests, they may or may not let the public and the press into a proceeding. If you remember during the George Zimmerman, Trayvon Martin trial, the jurors, all the names of the jurors are still secret, and the media was not allowed to photograph their faces. The names of the jurors generally are subject to disclosure, but for the purposes of this trial, the judge decided that she would seal the identity of jurors for 6 months following the trial. She has the authority to do that under the U.S. Constitution. But today we're going to talk almost exclusively about the Sunshine Law as it applies to local governments. If you have any questions, as I said, while I'm talking, come up and ask. If there's a more specific question, write it down and someone will just wave your hand and someone will come pick up the card. When I started at the foundation, I came from the legislature, as I said, where I had worked exclusively on the public records law. And I looked at the Sunshine Law. Public records law is all a huge chapter. It's chapter 119. There's tons of case law. There's a lot to know about it. I sat down, I looked at the open meetings law. It's like a few paragraphs. How hard could this be? There are only 3 requirements. This is the most complicated area of law I've ever dealt with, only because of the interpretation of certain aspects of the law. So if we look at the 3 requirements, meetings of public agencies must be open to the public. One of the first questions after this law became effective in 1967, very first question asked the court, what is a meeting? We all know what a meeting is, or we think we do. In some states, the right of access to a public meeting applies only if a quorum is present. But our courts, the Florida Supreme Court, back in 68 or 69 said, a meeting is any discussion of public business by two or more members of the same board or commission, assuming future action might be taken. Any discussion of public business between two or more members of the same board or commission, if it seems as though foreseeable action could be taken. I thought I knew what open meant. Then the first DCA said, no, you were wrong, but now the legislature agrees with me again. We'll talk about what open means in a minute. Reasonable notice of such meetings must be given. What does reasonable mean? It's not defined in the statutes. So there's been case law to interpret what reasonable means. And then minutes must be taken. I always called this the no-brainer requirement, but now minutes are all of a sudden, we're hearing lots of questions about minutes. Oh, well, the county usually records its meetings, and we have a recording of the minutes, and then the county administrator takes those recordings and turns them into minutes, but the recorder was at work, so we don't have any minutes. Or we have minutes, and they're recorded on this disc, but there's no machine in the state of Florida that can read that disc. So here are the minutes, take it to the Smithsonian. Meeting came to order 12:05, all commissioners but 3 present. New business was discussed, old business was discussed, meeting adjourned at 4:30. What happened? Who was there? Those are the kinds of questions we get about minutes. So what is a meeting? Generally, the Sunshine Law applies to any gathering, whether formal or informal, of 2 or more members of the same board or commission to discuss some issue on which foreseeable action will be taken, whether formal or informal. It doesn't matter whether the meeting is prearranged or not. We had a case over, I think it was in Volusia County, it was somewhere on the East Coast, Central East Coast, where 2 commissioners lived on the same cul-de-sac. And every morning, their neighbor, who lived between them, noticed that these 2 commissioners came out of their house about the same time every morning, in their bathrobes, holding their coffee. They'd go to the end of the drive, they'd pick up the newspaper, and they would stand there and talk for 10, 15, 20, sometimes 45 minutes. And the neighbor was getting a little curious because this happened almost every day. So one morning he went out with his paper and his bathrobe. They were discussing county business in their bathrobes at 6 o'clock in the morning. Sunshine Law applied. They could talk about anything they wanted to talk about with the exception of county business. So whether formal or informal, it doesn't matter. The Sunshine Law is going to apply to any discussion of public business on which foreseeable action might be taken. A lot of people get hung up on that word foreseeable. Well, we fired the guy last week. We can talk about it now. I can't tell you how many times someone is fired one week and rehired with a raise the following week. My suggestion is just don't talk about public business. If you're members of a board, a commission, a committee, a task force, don't talk to the other members about the business of that collegial body. There are so many more interesting things to talk about. I had a friend who was on, I've been subject to the Sunshine many times. I'm appointed by, Governor Chris to this commission or Jeb Bush to that task force. As a member, as an appointed member, I'm subject to the Sunshine. and I served with a very dear friend of mine who lives in St. Petersburg on Governor Christ's Commission on Open Government Reform. And she would come up to Tallahassee and trying to save the state some money, and I'd always invite her to stay with me. And she said, I can't stay with you. We're on the commission. We're allowed to be friends. I said, we can talk. You've got a husband, I've got a husband. You've got a boss, I've got a boss. You've got kids, I've got kids. Why would we talk about commission business? You're allowed to socialize. You're allowed to be friends with people on the same board or commission. You're just not allowed to talk about public business together, except at a meeting opened and noticed to the public. Okay, these are questions in here for you to answer. 2 members of the City Commission are annoyed by Mr. Smith, a self-appointed watchdog. Mr. Smith is extremely critical of everything the City Commission does. 2 commissioners arrange a conference call with the city manager to discuss what action the commission might take to address the Smith problem. Is this a violation of law? Yes. As a rule, the city manager, as an administrative officer, is not going to be subject to the sunshine. As a rule, there may be times when the city manager will be subject, but as a rule, the city manager is not subject to the sunshine. But the 2 commissioners cannot have a conversation about what might happen to deal with Mr. Smith via telephone. The Florida Supreme Court has said that the Sunshine Law is to be construed so as to frustrate all evasive devices. And the law is going to apply to deliberations and discussions between 2 or more members of the same board on any issue on which foreseeable action might be taken. And the use of a telephone to conduct such discussions does not remove the conversation from the requirements of the law. You might recognize the name in there. This is a case involving W.D. Childers. Public board members can't use computers to conduct private discussions among themselves either. So if you're emailing members of your board or commission about public business, 1, those emails are a public record subject to disclosure even if you're using your personal computer and your personal email account. And it could be a violation of law, of the Sunshine Law. We had a huge case in the city of Venice a number of years ago where the commissioners, there were 9 or 10 of them, were emailing one another about some controversial issue that they were dealing with. They went so far as to give themselves code names in this email correspondence. And a citizen made a public records request for all of the email correspondence relating to this issue, and he got a couple of hundred emails that were on the city server. But it was pretty clear to him when he read those emails that there was more correspondence. And so he rewrote his public records request and said he wanted all of the email, public record email, stored on the commissioner's personal computers. He should have gotten that in the first place with his first request when he said all correspondence, but he didn't get it. And some of the commissioners said, oh, well, I deleted it. Some of them said you can't have it. This went on and on and on. The citizen went to the court and got the judge to issue an order demanding that every commissioner turn his personal computer over to the court for an in-camera inspection. And there were tens of thousands of emails on those personal computers. So the citizen who had already filed a complaint in court alleging a violation of the public records law amended that complaint to include violations of the Sunshine Law. because they were not allowed to communicate with one another about this deal via email. Now, there's a very simple solution. After that case, it was settled for a large amount of money. I should say there are no damages for violations of the Public Records Law or the Sunshine Law. But if the city were to get sued and the city were to lose, the city will be required to pay the attorney's fees and court costs for the plaintiff. And in the case of Venice, the plaintiff's court costs were $700,000 and attorney's fees were $780,000. The case went on. They're not usually so big. The case went on and on and on. But after that case and news about that case came out, a lot of cities and counties and school boards adopted policies saying we don't want any of our employees or any of our public officials using personal computers to communicate with one another. If you took my personal computer away from me and you took you see me, I got my iPad and my smartphone. If you took those away from me and told me that I could only use my First Amendment Foundation laptop, you would cut my productivity by more than half. You want me, well, not you, my board wants me working at 9 o'clock at night or at 6 o'clock in the morning. The easiest thing to do, and as I said, when I've been on these boards and task force myself, I don't get a government email address. I use my First Amendment Foundation email address. But what I would do, for example, when I was on the commission, the CRISP Commission, I would simply CC the staff director at her government email address. So all of my email correspondence went through the governor's server. So if there was a public records request made, she had it all. I would still be required to produce it from my laptop if I got a public records request, but the government had it too. It was on the governor's server, and that resolved a lot of those problems. And it's a very simple solution. Some people will copy it onto a thumb drive and drop it at the city clerk's office. But the easiest thing to do is just CC yourself at your government email account or CC the records custodian. And that way they're all there. Anybody have any questions? Okay. Another question for you. Mr. Smith and reporter Rick want to attend a meeting of an advisory committee formed by the City Commission. Now, this is just general. It's not City of Pensacola, it's the city. Of an advisory committee formed by the City Commission to make recommendations about possible reductions to city staff. The advisory committee is comprised of the city manager, the city personnel director, and 5 private citizens active in city government. Not one elected official is on that advisory committee. Can Mr. Smith and Rick attend the meeting? Yes. Because that committee is making recommendations. Remember I said Sunshine applies to the entire deliberative process. If any part of that process is delegated, Sunshine follows the delegation. So the Sunshine Law will apply because they're making recommendations, even if those recommendations aren't binding. So who's covered by the Sunshine Law? Obviously, all public agencies in the state agencies, local governments, school boards, and special districts. Advisory boards and committees formed for the purpose of making recommendations will be subject to the Sunshine. If this advisory committee was just the staff reduction committee, and the commission said, go out, talk to cities of similar size, see how they've handled this. How many did they reduce their staff by? How much money did they save? And just report the facts back to us, Sunshine Law would not have applied. Sunshine does not apply to fact-finding by staff. But if staff is going to make a recommendation, or you form a committee of all private citizens to make a recommendation, or to act on behalf of the commission, the Sunshine Law is going to apply. So advisory boards and committees formed for the purposes of making recommendations. Private companies doing business on behalf of a government agency may be subject to the Sunshine. This one's a little harder. There is a list of factors, it's called the Schwab test, that the courts use when they're trying to determine whether a private company or a private individual is going to be subject to the Sunshine Law and to the Public Records Law. It's a totality of the factors. So, for example, a number of years ago, University of Florida was looking for a new president. They hired an out-of-state headhunting firm to go out and search for candidates, to interview those candidates, and to winnow the numbers down to a manageable 5 finalists. That out-of-state headhunter was subject to the Sunshine Law because that winnowing down is making a recommendation, basically. And even though it's a private company and even though it's out of state, Sunshine Law applied. There's no personnel exception to the Sunshine Law. And all of the letters and letters of reference and applications, resumes, those are all public records subject to disclosure. So the out-of-state headhunting firm. And this, we have a lot of private companies now doing business on behalf of Florida. During Jebb's administration, they privatized the state payroll. And we have a private company now doing what government used to do. That private company is subject to the Public Records Law and may be subject under certain circumstances to the Sunshine Law. So acting on behalf of, that's the critical phrase. If you enter into a contract with IBM to purchase new computers for the city, that's not going to subject IBM to the Sunshine Law. That's a contract for goods. It's when you have a contract for services. And there's been a big change to the Public Records Law in terms of contracts for services that we'll talk about this afternoon. This next one person acting on behalf of, is something of an eye-opener. Remember I said that the Supreme Court said Sunshine Law is to be construed so as to frustrate all evasive devices. Sunshine Law applies to 2 or more members of the same board or commission. You can't avoid the sunshine by appointing one person to act on behalf of the entire board in an attempt to avoid the sunshine, because the sunshine is still going to apply. The best case we have on this came out of Southwest Florida. A fire board, a commission, appointed one member of the board to negotiate a contract on behalf of the entire fire commission to provide fire services. The commissioner they appointed didn't have the authority to sign the contract, but he did have the authority to accept or reject offers. And in that case, the court said the Sunshine Law applied because he was acting on behalf of the entire board or commission. At UF, when they were trying to get rid of the current president, they appointed one member of the Board of Regents to negotiate his exit contract. Sunshine Law applied because that one person was acting on behalf of the entire board. So one person acting on behalf of can be subject to the sunshine under certain circumstances. Now, if, say, this guy from the Board of Regents said, well, if I just go talk to the president, maybe I can figure this out, and he had no authority to act on behalf of, he just did it voluntarily out of the goodness of his heart, Sunshine Law probably wouldn't have applied because it had no legal effect. But because he was delegated to act on behalf of, Sunshine Law applied. Does that make sense to everybody? And this bottom one, members and officers elect, it is not a new provision, but it is now in law. We had case law up until a couple years ago that said the Sunshine Law applies to a board member or a commissioner once the election results are certified. So the election's in November, results are usually certified within a month, but you don't take office till January. You will be subject to the Sunshine and the Public Records Law from the time the election is certified until you take office. We had Governor Scott ran into a few problems with that one. His transition team making recommendations, because he was subject to the Sunshine, anybody he appoints to make recommendations on his behalf is going to be subject to the Sunshine and the Public Records Law. And so, some pretty radical changes were made in the first few weeks after Governor Scott took office. And of course, people are going to start asking questions like, where did this come from? Who recommended that? And they started making public records requests. And it turned out that Governor Scott did not keep any of the records from his transition team. We didn't know that for a number of months. We made the public records request. I made one as well. We found out about 4 or 5 months later that he had been using this out-of-state email system, and that they had wiped all of the public records off the system. They were not retrievable. He's got a big problem on his hands because those are public records subject to disclosure, subject to retention. And he did a phenomenal job of going back and trying to recreate and get all of those records. He went to every individual member up on his transition team. I ended up receiving about 50,000 emails. I didn't get them all, but I got most of them. And he tried really hard. Nobody sued him over it. And then he came during the next session and asked the legislature to amend the law to specify that members and officers elect are subject to both the Public Records Law and the Sunshine Law. And that bill passed. So once the election is certified, then you will be subject to the Sunshine and the Public Records Law. If you are a challenger under this, you are allowed to talk to the incumbent you just beat, because you're no longer serving on the same board. But you're not allowed to talk to the other members of the board, except in compliance with the Sunshine. So as I said, advisory boards and committees created pursuant to law or ordinance or otherwise established are going to be subject to the Sunshine, even if their recommendations are not binding. The Commission on Open Government Reform, we worked for 2 years. We made 50 recommendations. We rewrote the Public Records Law and the Open Meetings Law. I don't think the legislature even looked at it. Clearly, they haven't looked at it. But everything we did in that 2-year period, we were subject to the Sunshine and the Public Records Law because we were making recommendations. Staff meetings are not generally subject to the Sunshine. I can't tell you how this disappoints young reporters who really want to sit in on your staff meetings. But they're not subject. Staff is not generally subject to the Sunshine. But if staff were to be appointed to make recommendations to the commission and the commission's going to take action on the issue, Sunshine Law might apply. But in your routine work, you're not subject to the Sunshine Law. Staff should refrain from polling members on specific issues which will come before the board for consideration. So the school superintendent, they've got a school board meeting. They're going to be talking about closing 4 schools in the district. It's very controversial. The school superintendent, prior to that meeting, goes and talks to each member of the school board to make sure they understand what they're voting on, understand the ramifications to the community, understand the financial costs and savings, answering questions. That's the superintendent's job. Sunshine Law will not apply. But if the superintendent was to go to Mrs. Jones and say, okay, Mrs. Jones, I really want to know how this is going to come out. Are you for it or against it? And Jones says, well, I'm for it. And then he goes to Mr. Smith, and Mr. Smith says, well, you know, I'm really worried about closing Pineview, so you tell Jones that if she'll agree not to do Pineview, I'll vote for it. And the superintendent polls the members, violation of sunshine, or relays information from one commissioner to another, violation of sunshine. But to answer questions, that's their job. And they should be providing information and answering questions to make sure that the elected officials are well informed and understand the issues. They just should not be polling them or relaying information back and forth. So the Sunshine Law can apply to meetings between a board member and an individual who is not a board member when that person is being used as a liaison between 2 or more board members, or to conduct a de facto meeting of board members. There was a case, I think, again, over in Volusia. Maybe it was Duval. They get in a lot of trouble over there. Where we had 2 members of the county commission using a private citizen as a conduit. The commissioner would call this citizen and say, tell my friend Bob over there that I'm going to vote in favor of this, but I need him to do this for me. And they were using that citizen as a conduit. Sunshine Law applied. The commissioners were in violation of law. People, you know, some of this you say, come on. I get this, well, how are we supposed to conduct business if we can't talk to each other? If Florida's had a sunshine law, as I said, since 1967, business manages to get done. I mean, if you want to talk about dysfunctional, look at Congress. But business is getting done. But what you have to realize, when you work for the city, you represent people as an elected or appointed official. People care very deeply about these laws. I had a call, it was a number of years ago now, but a woman called me up and she said, I think my town council has violated the sunshine law. It was like 8:30 in the morning, and on a Monday morning. And I said, well, how did they do that? And she said, well, I went to church yesterday, and then we went out to lunch, and when we came back from lunch, there were flowers in the median strip. I've been to this town many times. It's a major highway and Main Street, but there's no traffic light. There's what we call in Tallahassee a traffic calmer, a median strip with a blinking light, just to make people slow down. She said, those flowers weren't there before I went to church. And so I called my my town councilman and asked him where the flowers came from. And he said, oh, well, Councilman Jones's wife planted them. And she said, under whose authority? And it turned out that Councilman Jones' wife, this median strip was really ugly. It was full of trash and weeds. She got tired of looking at it. So she said, can I just go out there and put some flowers in it? And he said, well, I don't know. It's not I don't have the authority. Let me call and see. So he called a couple of his council members. She was going to pay for it. She was going to do the work. She was going to maintain it. It wasn't going to cost the town a dime. And so they all said, sure, great idea. So after church that Sunday, she goes out and plants the flowers, and all hell broke loose. I got 11 phone calls in 2 hours. Who gave them the authority? And true, it was technically a violation of sunshine. And I finally said to the 11th caller, I said, it's flowers. And the response was, it's flowers today and a nuclear waste site tomorrow. You just can't sometimes get through to them. It's flowers. But she was right. Technically, there was a violation of sunshine, so the town council called me up and said, would you come down and do a sunshine seminar for us? Yes. You just have to remember, and I know because I've been on those boards, and I'm usually the squeaky wheel on the board, and there's one other person that agrees with me, and everybody else disagrees with me, and my inclination is to call the person who aligns with me and strategize. Can't do it. Sunshine law applies. So single members of the board will be subject to the sunshine if that person has been delegated the authority to act on behalf of. As I said, if it's purely voluntary, there's been no delegation. I went out and worked this great deal here, sunshine law probably wouldn't apply. But the delegation could be formal or informal. It could be, okay, Bob, go out and see what you can get done on this. Delegation. Members elect, as I said, transition teams appointed by a member or office elect will be subject to, and there's the new provision, it's now in the sunshine law. So after a rather contentious, not that they're not contentious ever, city commission meeting at which potential cuts to staff are discussed, Mr. Smith decides to go to his favorite bar where he had to nurse a horrible headache. When he gets there, he sees 3 city commissioners sitting at a table talking. Mr. Smith takes a seat close to the commissioners and hears them planning a golf outing for the following Saturday. Are the commissioners violating the sunshine law? No. They are not. They're allowed to golf together. We even have an attorney general's opinion that says 2 city commissioners can marry each other. Whenever I look at my city commission meetings, it sort of gives me... They can't talk about city business. Now, if he got close to them and he heard them talking about who should get fired and who shouldn't, he had the right to pull out a chair and sit down. So that's a meeting subject to the sunshine. And there is a presumption of openness in Florida. We presume that a discussion between 2 or more members of the same board or commission is a meeting subject to the sunshine. And Mr. Smith would have a right to go up and very politely ask the commissioners what they were talking about. But a lot of people stretch this law, and by people I mean citizens, reporters, and public officials, to points of extreme. I had a woman who was elected to a county commission in a very rural county call me up after about 3 weeks in office, and she said, I'm quitting. Why are you quitting? Everywhere I go, I can't go to my son's soccer game, I can't go to the post office, I can't go to the grocery store without bumping into another commissioner. I've become a prisoner in my own home. You're allowed to bump into them. You're allowed to socialize. Just don't talk about commission business. I can't tell you how many times I get calls from citizens saying, well, I saw my commissioners at the fishnet last night. Well, they can't go out to eat. Sunshine applies only to the discussion of public business. So when does it not apply? As I said, when a committee has been established for the sole purpose of fact-finding, gathering information and reporting the facts, sunshine law will not apply. So we have a new, hiring a new city manager. We get 37 applicants. The commissioner has to vote on this, so sunshine's going to apply. They appoint a committee of staffers to go through, make sure that everybody had a letter of introduction, a resume, their references, whatever is required. They just make sure everybody's got everything. They pull everything together. They call those references, yes, good employee, no, bad employee, and they just turn all the information over to the commission. Sunshine law is not going to apply. But if they do the same thing, and then they start ranking these people, this person's got more, education, more experience, and we're going to give you the top 5 candidates, sunshine is going to apply to the discussions of staff. And if staff does any interviews, sunshine's going to apply to those interviews, because they're now making a recommendation. Strictly fact-finding, sunshine does not apply. And this second point here is very important. And this case, I have to say, surprised me greatly. Fact-finding exception applies only to advisory committees and not to the board with the ultimate decision-making authority. So your staff can fact-find as a group, but your commission cannot. I don't agree with this case. And the facts were bizarre to me. I mean, the decision was bizarre. The facts were pretty normal. The Seminole County School Board was looking at potential sites for a new school. So they put all of the school board members on a school bus. They sat them like 3 seats apart so they couldn't speak. School board attorney, I'm surprised they didn't put duct tape over their mouths. School board attorney was on there. I think a reporter was on there. But, the superintendent was on there. And they had one expert on the bus explaining the merits of this site over that site. Nobody asked any questions. Not one school board member opened his or her mouth. All testimony in the case, facts stipulated. They did not speak to each other. The court found a sunshine violation because they were on the bus receiving information from an expert. I still don't understand it. I don't know how they got there, but that's the law. So don't go as a body on a fact-finding mission. There was just a case over in Brevard County, 2 school board members and the superintendent went to visit a school, asked a couple of questions of the parents, of the teachers there, sunshine violation. No evidence that the school board members discussed this themselves, but they asked a bunch of questions of the teacher. Sunshine law applied. So until either the legislature fixes this or we have a different case, you can't do fact-finding as a collegial body. Community and political forums sponsored by a private organization are not subject to the sunshine law. So prior to the next election, the League of Women Voters is going to have the mayor, his challenger, all of the incumbents, their challengers up here, and they're going to have a community forum at which everybody will be invited to ask any question of anybody sitting up there. Sunshine law does not apply. It is a forum sponsored by a private organization. This has come up recently when we had a commissioner hold a public forum and he invited other commissioners to come discuss issues. That's really a town hall meeting. Sunshine law is going to apply. But if it's a community or political forum A neighborhood association wants the 3 commissioners who represent that neighborhood to come talk to them about issues relating to them, and everybody's invited to attend. It's open, it's sponsored by the community itself. Sunshine Law will not apply. I recommend in cases like that that you provide notice of the fact that there's going to be this political forum, but you're not required by law to do that. But if the commissioners, some provocative questions are being asked by the audience and the commissioners start leaning back in their chairs and talking like this, Sunshine Law could apply to that. They're not allowed to start discussing. As long as they're going this way and not this way, there's no sunshine problem. And the ACLU hates that one, but too bad. Social gatherings attended by 2 or more members of the same board or commission are not subject to the sunshine. Just be careful that you don't start talking about public business. And I get calls from commissioners. I was at a cocktail party and 3 of us were there and 2 of them started talking about some issue what do I do? I said, walk away. Just walk away. Don't participate. Don't stand there and listen. Walk away. It's not appropriate, and just walk away. City Commission is holding a special meeting to discuss possible staff layoffs and has notified reporter Rick about the upcoming meeting. By informing the reporter, has the Commission satisfied the Sunshine Law's notice requirements? No. Rick and the newspaper are under no legal obligation to report the fact that the Commission is meeting. So notice, what does reasonable mean? The court said sufficient so as to inform those who might be interested in attending. This means that notice must be reasonable in terms of content. What items do you intend to discuss at the meeting? Give me some idea of what you're going to talk about. It must be reasonable in terms of timing, and it must be reasonable in terms of placement. So it's going to be reasonable under the circumstances. I live on a big city park in Tallahassee, and they were going to do all this work. The city was Parks and Rec. They were going to do all this improvements on the park. And they put notice of the first 2 general meetings on the bulletin board in the community center, at the entrance at every entrance to the park, and in the community newsletter for those who lived around the park. So anybody who used the rec center, anybody who comes into the park, anybody who lives on the park got notice. Reasonable under the circumstances. They didn't have to take out an ad in the Tallahassee Democrat. Then, however, when they got a specific plan about what they were going to do, they sent all the property owners a letter saying, we're having this special meeting at the community center to discuss the specific plans. We want the input of those who live on the park. They sent every landowner on the park a letter with the exception of me. They didn't do it intentionally. When they found out I didn't get a letter, they got a little worried and sent a bunch of people, engineers and all these people over to my house, because it turns out that of all the people who live on the park, my property is the only property that's actually affected by what they do. So what can we do to make this right, blah, blah. So we're talking. I'm not going to, I understand mistakes happen. I'm glad you came to talk to me. By the way, that security light in the basketball court, it shines right in my bedroom window. Oh, we can fix that. We can fix that. Those, guys on the tennis court are like screaming and cussing at each other at 6:30. Well, we'll fix that. My husband said, why didn't you just ask him for a new car? If you go to that extreme step of providing special notice, you have to make sure everybody gets that notice. Had they put the notice in the newspaper and I just hadn't seen it, that would have been my tough luck. But they took that special step by writing letters to us. And they didn't have to do that under the Sunshine Law. Now, you want to note that there are other statutes, codes, and ordinances that could impose different and more stringent requirements. Land use matters, for example, have really stringent requirements about how and when and where you must provide notice. State agencies and some special districts are subject to the Administrative Procedures Act, Chapter 120, which lays out everything, but you're stuck with 286, which says reasonable notice must be provided. So it's going to be variable depending on the facts. In each case, you must give notice at such a time and in such a manner as will enable the media and the general public to decide whether they want to attend the meeting. And this is a question that comes up quite a bit. You do not have to put an agenda in your notice. It just says reasonable notice. You should include, particularly for the city commission, you should include a summarization of the topics you intend to discuss. But when the mayor creates the special task force on getting rid of the leash laws in the city of Pensacola, we'll know what they're talking about, right? So just to say that special task force is meeting would be sufficient. But when you have a school board, a county commission, a city commission, and they could be talking about a wide range of topics, include at least a summary of the topics you intend to discuss. So you come into the meeting, say you've got agended items 1 through 10. Halfway through the meeting, one of your commissioners says, but you know, this leads me to I think I want to discuss this other issue. It's not on the agenda. You're allowed to bring it up and to discuss it, even though it was not included on the agenda. So you're not limited strictly to the items on the agenda. The Attorney General recommends that you bring it up for discussion, but you table action on it until your next regularly scheduled meeting or until you can hold a special meeting or whatever you need. But that's not it's a recommendation, it's not a legal requirement. So if the commissioner brings it up and the commission votes it out, that is not a violation of law, even though it wasn't on the agenda. The only time it would be a violation is if that was done intentionally. And that did happen once down in Miami, where they intentionally left off an item because they knew it would be controversial. They didn't want a lot of people talking about it, so they intentionally left it off. At 2 o'clock in the morning, after the Miami Herald reporter fell asleep, they brought it up and voted it out. So, but there were records showing that they had done this intentionally. That was a problem. Any questions? Okay. All right, this is the one that's near and dear to my heart. Mr. Smith wants to speak at the City Commission meeting about possible staff reductions, but the Commission has a policy prohibiting public participation. Does Mr. Smith have a right to speak? As of October 1st, yes. Until October 1st, no. The Florida Supreme Court said, look at that, back in 1969, that the public has an inalienable right to be present and to be heard at all deliberations wherein decisions affecting the public are made. We had a right, an inalienable right, to be present and to be heard. But then we had some later cases that said, well, maybe not inalienable. And the Wood v. Marston case made a distinction between legislative type meetings and executive type meetings, and said when they're going to be taking action on an item, public has to be given a right to speak. But if they're just workshopping an item, no right to speak. And that's the way everybody worked until 2010, when we had the Keesler case. You might recognize that one. And in the Keesler case, the first DCA said there is no explicit right to speak in the Sunshine Law, and we don't care what the Florida Supreme Court said, there's no right to speak. Then we had Grabsky, then we had Kennedy, all saying the same thing. This was an outrage to a big bunch of people in the state of Florida. How do our public officials know what we want them to do if they won't let us speak to them? And a lot of agencies, not many, changed their policies regarding the right to speak. Some did. In fact, I got an email last night. A city over on the East Coast is considering a policy that allows the public to ask a question, but only if it is rhetorical in nature. And we've had some real doozies. We had one school board adopted a policy that said everybody gets the right to speak so long as you don't criticize a member of the school board. So you can tell us you like us, but you can't tell us you don't. One city had a policy that said everybody gets to speak, but you have to submit the content of your remarks to the city manager 10 days in advance of the meeting, and the city manager will decide whether you get to speak based on what you want to say. My favorite was a guy who called me up late at night, and he said, my city just passed an ordinance saying I can't speak at a public meeting. I said, you specifically can't speak? He said, that's right, I'm not allowed to speak. And I didn't believe him. So I said, fax me, this before email, fax me a copy of the ordinance. Sure enough, from this point forward, Tom Brown is not allowed to speak at public meetings. So I called him the next day. I said, I've never been in a courtroom. I am not a litigator, but I think I could win this one for you. You're allowed to adopt reasonable rules which allow for the orderly progression of a meeting that require orderly behavior, no shouting, no shoving, no pushing, no purse throwing, no finger biting. Everybody gets 2 minutes, everybody gets 3 minutes. Reasonable rules. That was the case before Keesler, and it is going to be the case as of October 1st. Committee substitute for Senate Bill 50, which will be codified as 286.0114, says that every board and every commission must allow the public a reasonable opportunity to be heard on propositions before the board or commission. A reasonable opportunity to be heard. Now this is important. The right to speak does not have to be at the same meeting at which the proposition is being considered. But it must occur within reasonable proximity. So you could have a workshop on an issue, allow the public to comment, a week later have your regular meeting and take action. That would be allowable under this. And this will, I'm not sure how this is going to affect consent agendas, except that as my example, if you had a workshop on the issue and you allowed public comment, and then you put it on the consent agenda for the next meeting, that would work. But I've been working with a woman, she's actually the former city clerk of a small city in southeast Florida, where her city commission does things only by consent agenda. There is everything's consent agenda. So there's never any discussion of anything. They come in, they got the consent agenda, and they vote. I think that's a violation of law. I don't know which one. Certainly a violation of my sense of democracy. And we had Senator Negron was the sponsor of this bill. And for 3 years, it took 3 years to get it passed. One of the issues that came up just before it passed, this idea that you don't have to have, the right to speak doesn't have to be at the same meeting. It was a school board, it was the Brevard County School Board, was having a meeting at which they were going to vote to close 4 schools within the school district. And hundreds of people showed up for this meeting, including the mayors from 3 major towns in the county, members of the county commission, teachers, you name it. Hundreds of people showed up for this meeting, and they wouldn't allow anybody to speak. Nobody, not even the mayors got to speak. I mean, this is going to have a huge impact. Do you imagine if your school, Escambia County School Board, said, well, we're going to close 5 schools in Escambia County. How's that going to affect your town? And in their defense, the school board members said, well, we held a meeting for public comment 2 weeks ago, and we let anybody who wanted to speak then. And well, that's pretty reasonable. Okay, that's what this, foresees those kinds of situations. But then I found out not one school board member was in attendance at that meeting. So sure, public, you get to speak, but we're not going to listen to you. And that's the frustration, I think, for most people. We had over in, I forget which county it was now, in Northeast Florida, the county commission had a policy, no public speaking, and the citizens were outraged. And they called me up, and I said, well, they don't have to let you speak. Well, what do we do about it? I said, well, I'm a kid of the 60s, protest. You talk to the newspaper, get editorials written, blog about it. Start putting some pressure on them. And so they did, and the county commission said, okay, you're right, we're wrong. We're going to adopt a speaking policy. For 1 hour before every commission meeting, the public, it'll be open mic time. You can talk about whatever you want to talk about. The local newspaper editorialized, great job, I'm glad you listened, everybody's all excited. The next day I get all these phone calls, oh, we got to speak all right, but not one of our elected representatives was there. What's the point of that? How arrogant is that? And that's the problem most people have with this. So this was a bill we supported. I think it's reasonable. We worked really hard with the League of Cities and the Association of Counties to try to make it not too burdensome. It's reasonable rules. You do not have to give Mr. Smith that mic and let him keep it. Everybody gets 2 minutes. Everybody gets 3 minutes. All of you over there agree with us. All of you over here disagree with us. Pick 3 people from each side to represent your views. Everybody else submit your comments in writing and we'll make them part of the record. Reasonable. But you can't tell people to shut up and sit down. Go on YouTube. Look for Father Nathan. Look for Fane Lozman. Fane Lozman has been arrested and taken out. He also just won a lawsuit in the U.S. Supreme Court. So I think that this is a good compromise. It gives people an opportunity, but it's not overly burdensome. So it becomes effective October 1st. If you go look at the statutes now, you'll actually see it in the 2013 statutes, but it's not effective until October 1st. Mr. Smith starts criticizing a member of the city commission during the time set aside, but the commission has a policy that says everyone gets to speak, so long as the speaker doesn't criticize the members. No. Reasonable rules which require orderly behavior and allow for the orderly progression of the meeting. No offensive name calling. We had a commissioner and a citizen who didn't like each other, and it was usually the commissioner that started calling the citizen some offensive names. But reasonable rules, they have to be uniformly applied, and they have to be content and speaker neutral. You can say, all right, we're going to have 5 minutes of testimony on this issue, and 5 minutes of testimony on this issue. and then have 30 minutes in the middle or the end or the beginning to allow anybody to bring other issues. You don't have to, it's not wide open. You can limit it. You don't want to be here all night. The use of non-disruptive recording devices, whether cameras or tape recorders, cannot be banned. And I got a call about this one last week. A man was sitting in the front row, just holding his iPad up, recording the meeting. He was kicked out of the meeting. Can't do that. The prohibition on taping conversations does not apply at a public meeting. And there's actually a weird provision in the Sunshine Law that says if a citizen might want to contest action taken at a commission meeting, that citizen has to have an accurate record of what happened at that meeting. So they may be required to record it. So as long as they're not being disruptive, they have every right to record, photograph, or videotape. The committee formed to make a recommendation to the City Commission about staff reductions is meeting in Mrs. Brown's kitchen. Is that okay? If it's okay, can the reporter and Mr. Smith attend the meeting? We know the committee is a Sunshine Committee, but can they meet in a private home? No. No. They can't first hold meetings at facilities which discriminate based on age, race, sex, economic status, which unreasonably restrict public access, and you have to hold meetings in facilities of sufficient size so as to accommodate the anticipated turnout. I think the Attorney General would frown pretty severely at a meeting held in Mrs. Smith's kitchen because too many people would be uncomfortable attending that meeting without an invitation. You should be holding meetings at public buildings which the public is free to enter. And we get these calls sometimes, particularly during election season. Well, the 3 incumbent commissioners just went up to a gated community to hold up, and we can't get in. Or they're at the naval base, and the barrier's down. We can't get in. Sunshine Law requires that people be free to enter. And for local governments, you have to hold them within your district, within your coverage area. We had that case with Ray Sampson and the board from the Northwest Florida College held a special meeting at the University Club in Tallahassee to discuss giving Mr. Sampson a part-time job at the college as he took office. This was one of the dumbest things I've ever seen. He announces the day he takes office as speaker that the college has given him a job, part-time job, for $120,000 a year. No big deal, that happens all the time, but he announced it the day he took office as speaker. So of course every reporter in Tallahassee starts looking into it. And that's when they found out about the hangar, that's when they found out about the secret meeting. And it wasn't a secret meeting, I shouldn't say that, because they did advertise it in the Northwest Florida Daily News. But they held the meeting 120 miles away from the college. And when the president was asked by reporters why he did that, he said, well, we wanted to accommodate Mr. Sampson. Well, he lives in Fort Walton Beach, and it was in August. He wasn't in Tallahassee. Then requests were made for the email correspondence between the commission, the members of the board, about this meeting, and lo and behold, there's an email from the president to the board saying, I know this is inconvenient, but we want to avoid the public, so we're having this meeting in Tallahassee. This is a perfect opportunity. Think before you send an email that says something like that. If it is a public record email, I was making some public records requests. It was a favor, actually, to the governor's office For the staff emails, because they were getting so many public records requests for staff emails, I said, I'll make it. I'll just make one, so you only have to deal with me, and I'll put it up in a Dropbox, and anybody who wants it can have it. It was a great idea. I had to quit after about a month. But one of the first batches of emails we got, the governor's top advisor, who was making $200,000 a year, sent an email to someone saying, please don't use my .gov email address. I'm trying to avoid the public records law. Here is my personal email address. Think before you write it. I can't tell you how many times I get emails from government officials and employees that just say, call me. Perfectly fine. Call me. So you shouldn't be holding meetings in private facilities unless you can accommodate everybody and make sure that everybody is free to attend. We've been getting calls also in the last few weeks. We got a lot of these after 9/11, as you might imagine. But in the last few weeks, we've been getting a lot of calls about people being required to provide proof of identity before entering a meeting. I don't think you can do that. I got a frantic call from a reporter who was told that she had to identify herself as a reporter in a public meeting. No, she does not. And this is a security. I understand the need for security, but there's got to be something short of making people identify themselves simply to attend a meeting. And I just got in a big fight with a publisher of a small newspaper down in Southwest Florida who's furious that his town council requires people who want to speak at a public meeting to identify themselves. That's totally appropriate. You're required to keep an accurate record of what happened at that meeting. And if you want somebody to fill out a speaker's card before speaking, that's appropriate, because you then have a record of who spoke. But if I'm just sitting in the back row and I just want to come in and listen, to make me show identification can be really chilling. So there's got to be some other security mechanism. And proving who you are walking in the door is not going to prove that I'm not a shoe bomber. So there's got to be some other way. Violations of sunshine can occur if board members discuss board business in a manner not generally audible to the public. Even though the meeting is not clandestine, it nonetheless violates the letter and the spirit of the law. And that's the conversations that you're sitting there at the podium and you're leaning back, talking like this. What we're seeing in some commission meetings lately, texting. Orange County is in a lot of trouble because they were not only texting one another, they were texting the lobbyists in the audience, and the lobbyists were telling the commissioners what to say. Those text messages are public records subject to disclosure because they relate to public business. Orange County is being sued in civil court, and they are being investigated by FDLE for a possible criminal intentional violation of the public records law. It's not that they were communicating with the lobbyists. That didn't violate the Sunshine Law. It's the fact that they didn't save those text messages. They deleted them from their phones. But they can't be texting each other. They can be texting each other. I said, look at that guy's shoes. Oh my God. That's fine. Or our wives meeting, to go somewhere. Are we going to go to the opera tomorrow night? That's fine. It's a little annoying to the people in the audience. That's not a violation of sunshine. But if you start texting about public business, that's a violation. We had it was actually pretty funny, a very conservative legislator who's always taking very, very conservative stances on social issues. And I don't know how many of you have been to the Capitol in Tallahassee, but you've got the floor, and all around it are the galleries where people sit up above you and can watch and actually look down on you. And this particular guy, who can be a little sanctimonious at times, a photographer for one of the major newspapers was standing up above him just as he opened his laptop to a picture of nude women dancing or something. And the photographer took a picture and captured the screen. So now they're very careful. They sit there, sort of with things tilted down and put them on their laps. People get upset, but, the city of Orange County was going to adopt a policy saying that everybody had to drop their personal communication devices in a basket as they entered a meeting. No. I'm sorry, I will turn off the volume, but I have a 92-year-old dad who, if something happened to him and I'm stuck in a meeting for 5 hours, what am I going to do? I'm not going to sit there and twiddle with my phone, but no, I'm sorry. That's why I carry this thing, because I need to have communication. But that to me seemed to be extreme. They have worked now. They claim to be the only local government in the country. I don't know if it's true or not. They have now acquired software that automatically captures their text messages. So it captures them and archives them. And the reporter who has been covering this story from the very beginning made a public records request, and he said he got like 6 weeks of text messages from all the county commissioners in a matter of minutes. There's technology that will solve our problem. So board members can use written ballots to cast votes. This question comes up periodically, and I think the 2014 manual is going to be more specific about this. So you can use written ballots to cast a vote if those votes are made openly at a public meeting, the name of the person who voted and his or her vote are written on the ballot and read into the record. The ballots themselves are public record, but they have to be read into the record. There are no secret votes, in other words. You're also required to vote if you're in attendance. You can't abstain from voting unless you have a conflict or a possible conflict of interest. I should also point out, and I don't understand this one either, when we were talking about where you can hold meetings, state agencies are allowed to hold meetings via teleconferencing. Local governments are not allowed to do that. In other words, you can't have a meeting via, GoToMeeting or GoToTraining. You have to be present in the room. A quorum must be present in order to hold a meeting. I don't really know why they make that distinction, except that the state agencies, it's a big state, and if DCF has to have a meeting, and they've got people in Tallahassee, people in Miami, people in Pensacola, people, in Daytona, that's going to be hard to get everybody together. That would be my guess as to why state agencies are allowed to do it, but local governments are not. So the City Commission is meeting to discuss the possible firing. Mr. Smith sees the commissioners sitting in the conference room, and he opens the door. The city manager says Mr. Smith can't attend because of the sensitive nature of the discussion. Can they keep Mr. Smith out? No. As I said, we have a presumption of openness. All meetings between two or more members of the same board or commission are open to the public unless there is a specific statutory exemption. If Mr. Smith opens that door and you have an exemption for the meeting, you can tell Mr. Smith to leave. Here's the statutory citation that says you can't come in. If you don't have a specific exemption, you can't close the meeting. And there's no general personnel exception. So if the city commission, most cities I deal with are sort of hierarchical. Certain positions only the commission can hire and fire. Everybody under that, the city manager or the city clerk, can hire and fire. If the city commission has to take action on the hiring or the firing, sunshine law is going to apply to all the interviews, the exit interviews, the evaluations, all of it. But if the city commission doesn't have to approve or doesn't take action on it, and it's the responsibility, pure responsibility for the city manager, sunshine law will not apply to the interviews and that sort of thing. So it's a question of who is responsible for the hiring and firing. Only the legislature is allowed to create an exemption to the constitutional right of access. So there is no balancing of interests. It's sensitive, it's personal, you might be squeamish, but if there's no exemption, you have to let them in. Not even the courts can balance interests. The courts are stuck with what the legislature says. Now, the courts might interpret what the legislature said, but the courts can't create an exemption. Only the legislature is allowed to do that. And if denied access, the person denied can demand the statutory citation authorizing closure. It's the responsibility of the agency to tell me why I can't attend or why I can't have that public record. You have to provide the exact statutory citation, and that's what's difficult. Guess how many exemptions there are total, sunshine law and public records law? Just throw out a number.
39.
I wish. There might be 39 in the public records law. 1,084. 1,084 exemptions to the public records law and the sunshine law combined. In the sunshine law, there are only 3 actually in the sunshine law. The rest of them are scattered throughout the statutes. And they're really hard to find. Now, there is a summary of the exemptions in the back of the Government and the Sunshine Manual. It's a summarization only. You really need to look at the actual statutory language. And there is, fortunately, a really good website, Online Sunshine, that has the Florida statutes online. You don't have to buy that $900 set of books anymore. And I'm pleased to say the city of Pensacola is one of the first cities to become a member of the First Amendment Foundation. And as a member, you will have access to our members only page when our new website goes live. And there will be a searchable database of all of the exemptions to the public records law and the sunshine law. So if you want to know if Social Security numbers are exempt, all you'd have to do is type in Social Security. And up would pop all of the exemptions. If you want to know if there are exemptions specific to municipalities, put in municipality and it'll pop up. That's the only way to find them. And it's your responsibility, as I said, your legal responsibility to tell me why I can't attend or why I can't have that record. So you have the burden of finding the exemption. Some of them we use all the time, but some of them, I sort of have this vague sense that there might be an exemption, but I've got to go find it. And you can always call me, I'll help you find it. And I should say, if you call me and you've got a specific problem or a specific question or you want to know this, I do not then turn around and call the newspaper. What you tell me stays with me. So you never have to worry about me spilling the beans. Okay, the 3 exemptions that are in the sunshine law itself. The litigation exemption, which is ironically the most litigated of all of the exemptions to the public records law and sunshine law combined. The purpose of this exemption is to allow the city of Pensacola to be on a level playing field with people suing the city. It applies to pending litigation to which the city is presently a party. So if I go outside and I trip on the sidewalk and I sue the city of Pensacola, you can evoke this exemption. If I get in an argument with the mayor and I think that he has slandered me, and I file a suit against the mayor, but the city is going to have to pay up if the mayor loses. The city is not a named party, but is a party in interest. You can claim this exemption. But it has to be a suit that has been filed, not threatened. The agency attorney must notify, in this case the city commission, at a public meeting that the attorney desires advice in the case of Barbara Peterson versus the city of Pensacola. That has to be stated at a public meeting. Then the city commissioners can go behind closed doors with their attorney to discuss settlement negotiations or strategy sessions related to litigation expenditures. That's all they can discuss. Should we settle? How much should we settle for? Should we hire expert witnesses? Should we hire outside counsel? How much is that going to cost? What's the limit of our liability insurance? Discussion only. And the only people who can attend that meeting, the chief executive officer, the attorney or attorneys representing the city, and the members of the city commission. Nobody else gets to go. And you can't take action. Nodding your head yes is action. Blinking twice is action. You can't take action. You're allowed to discuss, but you can't take action. The meeting must be recorded by a court reporter. Everything that is said is on the record. Everybody who's in attendance must be recorded, their titles, their names. And then once that litigation is concluded, the transcript becomes a public record. As I said, it's trying to create a level playing field. I should not be allowed to attend a meeting where you're discussing how much money you're going to settle my case for. So that's the protection. And the problem is people from every department in city government are invited in. You start talking about Barbara Peterson versus the city of Pensacola and the slip and fall case. Well, then you start talking about, well, maybe we should get Special Works in there and get, like all those sidewalks fixed. Or, the case where the city had the policy where you had to submit your comments to the city manager. The citizens sued. They held a litigation meeting, as they were allowed to do. At that meeting, however, they voted to change their policy. So they come out and said, sorry, Mr. So-and-so, your case is moot. We changed our policy. So now they're in federal court for violation of his First Amendment rights, and they're in state court for violation of the Sunshine Law. So just be careful, and most attorneys are pretty savvy about this. You just want to be careful, listen to your attorney, don't invite, if you have questions, you can call me, you can call Pat Gleason, just don't allow more people in, limit yourself to those discussions, and you'll be okay. The security exemption, this was actually in place prior to 9/11. It allows closure of portions of government meetings which would reveal security systems plans. Security system plan, there's also a public records exemption for those plans. It's defined in 119. The problem was, it was in some weird esoteric chapter and nobody could find it. And my phone was ringing off the hooks from local governments all over the state of Florida wanting to increase security. And so I knew where the exemption was, and in one of the 5 special sessions the legislature had after 9/11, they accepted our recommendation that the exemptions be moved into the Sunshine Law and the Public Records Law where they were easier to find. So there are protections in place for security systems plans. This is a relatively new exemption, the competitive solicitation exemption. We've not had a lot of litigation on it. I'm getting a lot of complaints about it. It seems pretty straightforward to me. Portions of a meeting at which a negotiation with a vendor is conducted, where a vendor makes an oral presentation or a vendor answers questions, will be exempt. And again, the idea is a level playing field. If we have 6 finalists and you go in alphabetical order, Mr. Adams should not be at a competitive disadvantage because Mr. Smith was allowed to sit in on Mr. Adams' presentation. So before this exemption, everybody got to go to those meetings. I think it's pretty narrow, but what's been happening is that some local governments have been closing meetings when it's not a competitive solicitation. In other words, it's not an invitation to bid. You have to qualify. So you present all, and then they're meeting in secret to talk about those people who are trying to qualify, and they're closing everything. So I think it's more a question of misinterpretation or misapplication than the exemption itself. I think the exemption's pretty narrow, and I think it's fair. Any questions about it? I mean, that's what we do try to do, is figure out when an exemption is needed and when it is simply in somebody's best interests. We had a fight a few years ago that I lost. A public records request was made of a county sheriff for records relating to the vaccinations of pets in the county. You have to get your dog or cat vaccinated. And the legislature passed a law saying that the veterinarians had to report to the county sheriff a list of those people whose dogs and cats were getting vaccinated. Well, a direct marketer saw this as a great opportunity, went to the sheriff and said, I want a list of all the dog and cat owners in Sarasota County, because I'm going to sell them pet care products much cheaper than the veterinarians do. So the veterinarians got all upset and said, we're going to sue you if you give up that list. And the direct marketer said, we're going to sue you if you don't give up that list. And so the sheriff's office went to the attorney general. The attorney general said, it's public record, you have to turn it over. So the sheriff turned it over and got sued by the Vets Association. And then the legislature created an exemption for the names of the pet owners, their names, their addresses. It was really ridiculous at one point. We managed to narrow it down. But anybody, if you register, if you get your dog vaccinated and it's reported to the sheriff, your identifying information will no longer be available, or your locating information. They first tried to tell me it was like the 101 Dalmatians, that if somebody found out that I had a valuable Irish setter, they were going to come to my house and steal it. And then they told me that it was the pet vet confidentiality requirement, that the veterinarian's not allowed to tell the public that, he just vaccinated Sissy. But I lost that one. But that we do try to keep things reasonable when we can. So the city commission, the attorney, informs the commissioners it may have been a violation of the law to refuse Mr. Smith the right to attend the meeting held to discuss potential layoffs. Mr. Smith said he's going to sue the commissioner's decision to fire the 10 staffers. What can the city commission do? Any ideas other than ask Mr. Smith to move? Pass the No Mr. Smith in Escambia County ordinance? Here's the problem. The law says that resolutions, rules, regulations, or formal actions taken at meetings held in violation of the law will not be binding. Any action taken at a meeting held in violation of the law is void ab initio, as if it never happened. So if Mr. Smith sued and won, those 10 staffers would be rehired. They were never fired. And this is why most people sue under the Sunshine Law. They want to void action. One hospital, public hospital, again in Volusia County, got sued. It was a board running a public hospital. They got sued. The court said they violated the law for 5 years. Can you imagine how many times that board took action in 5 years? And technically, all of those actions were void. In that case, the newspaper just wanted the board put on notice that they were subject to the sunshine. They were being very stubborn about it. They didn't set out to void anything, and they worked out a deal with the court where nothing was voided, so long as the board from that point forward complied with the law. But most people want to overturn action. If you want to make sure that those 10 staffers remain fired, you can hold what we call a cure meeting. Action taken at a meeting held in violation of the law can be cured if the offending agency takes independent final action in the sunshine. We call that a cure meeting. So the action will be cured. If Mr. Smith wins, those staffers will remain fired. But you've still violated the law. So you can cure the action, but you can't cure the violation. And it has to be independent final action. The first big case we had on this was with a man named Frank Zork over in Vero Beach. City Commission took action, put Mr. Zork out of business. Mr. Zork got mad and filed a lawsuit against him because they had violated the Sunshine Law. And they held a cure meeting. And they came into that first cure meeting and said, okay, everybody in favor of putting Mr. Zork out of business, raise your hand. And they ratified the action they had taken at the first meeting. The court said that was not an effective cure. You can't simply ratify action. You must hold, to the best of your ability, a full and frank discussion of the issues. To the best of your ability, recreate the discussions you had at that first meeting. This is the first time this has ever happened. I've been doing this for a long time. As I said, a few months ago, I think it was a city commission, might have been a county commission, hired. They were hiring somebody. They had 5 finalists. They decided at a meeting to hire candidate number 4. Well, they met in violation of the Sunshine. So they had to hold a cure meeting. At the cure meeting, at their full and frank independent final action, they decided to hire candidate number 1. So I don't know if they're getting sued now by candidate number 4 because he didn't get the job he was offered, but that's never happened before. But you have to take independent final action. So unintentional violations of the Sunshine Law are non-criminal infractions punishable by a fine of $500. I thought you provided notice. No, I thought you provided notice. Unintentional violation is a $500 fine. An intentional violation is a second-degree misdemeanor punishable by a fine of not more than $500 and not more than 60 days in jail. And I do want to tell you, Escambia County is home of the only person in the history of Florida to go to jail for intentional violation of the Sunshine Law. W.D. Childers, the only person in the history of Florida to go to jail for an intentional violation of law. Suspension and removal from office is far more common. That happens only if there's been an intentional violation. In other words, a court has said there's an intentional violation. You can be suspended pending the outcome of that trial. but a mere suspicion or an unintentional violation is not enough to get you suspended or removed from office. And you may have to pay attorney's fees and court costs, however. As I said, in the city of Venice, it was $750,000, $780,000 they had to pay to the plaintiff's attorney. Bert Fish Hospital Board just paid just shy of $1 million in attorney's fees for a sunshine violation case. So the court costs can be high. Attorney's fees can be high. But the fines are not significant, with the exception of jail time and suspension or removal from office. One point I would make is if you have a question about application of the sunshine or the public records law for that matter, and you go to the city attorney, not your personal attorney, you go to the city attorney and ask the city attorney if sunshine law applies, and the attorney says no, and a judge later disagrees, you will not be personally liable for any fines or fees. So, I mean, attorneys can be wrong. It's my father's favorite joke. 15 attorneys in the room and 16 different opinions. Some of this is just all subject to interpretation at this point, and it's not easy sometimes. But always ask your attorney, and then you will be protected personally. You will not be responsible for any fines or fees. So any questions from anybody? Anybody write anything down? No? I can't see too far out there. Okay, we're going to come back at 1 o'clock and talk about the public records law. It's a lot easier. You'll have time to get some coffee. I have mate if anybody wants it. And I'll see you back here at 1.